Well, good afternoon, everyone, and a happy new year to everyone from Innovate Ireland. And thanks for coming along to our first Innovate Ireland event of 2022. As you've just seen, I am recording this for our YouTube channel. So if it is okay for you to be here, then when we get to the Q&A, please turn on cameras. It's good if you can. It's good to see who's asking the questions. It's good to see so many familiar faces from the community on the call. You're, as ever, extremely welcome, and we appreciate your ongoing support. For the new faces, the new names on the call, my name's Charlie Tuxworth, and I'm one of the co-founders of Innovate Ireland. Innovate Ireland started out as really a very informal and a safe place, if you like, for a few of us to swap experiences, challenges, frustrations around innovation. We were all implementing innovation in established businesses, established organizations, and had discovered that there was really a lack of support available to us. All the focus was on startups and pure R&D. So eventually this led to the creation of Innovate Ireland, and we are now the go-to all-island community for practitioners, advocates, and explorers of innovation. We share some really good content, some best practice and thought leadership, and we're representing our members now at an international and a national level. So if you do enjoy the session today, check out our website, innovateireland.net, or join our LinkedIn group, and please spread the word about what we're doing. So on to today's topic. We all know that innovation is about creating value in one way or another from the generation and development of novel ideas. And some of those ideas eventually will become new products or services. And it would seem that many of us are simply just not doing enough or anything in some cases to protect the value that we create. So I'm delighted that today we're being joined by Joe Doyle, IP manager with Enterprise Ireland, to explain a little bit more about what IP is and how we can keep hold of it. So I'm going to pass over to Owen quickly, who will introduce Joe properly, and Owen will also manage the Q&A when we get to that bit. So Owen, over to you.
Thanks, Charlie, and we won't hold up Joe much here. And of course, Charlie's already introduced what Joe is talking about here. So really, I'm speaking just because I've known Joe a little bit longer and met him more often than Charlie. But just to note about Joe, that we know what he's doing. He's the IP manager. He's the IP manager for Enterprise Ireland, which in our island has a rather unique role, which Joe might elaborate on just a little bit when he speaks. But it allows us, because Joe is also a member of our community, an active member of Innovate Ireland, to say, can we find someone who can talk about this topic and not preach from on high, who still has a really deep understanding, so that we know where this is coming from and it's evidence, it's best practice. We can trust the source, we can trust the message. Well, and by the way, we're in a place, Innovate Ireland, where we can have a chat and knock a few holes, not be too polite to each other, to allow some good conversation to come from this. And that is kind of the purpose. We're doing a little chat, we're doing a little session. Yeah, there's a presentation, but Innovate Ireland is about the conversation. So all I'd add about Joe is that I know what his job title has been for a number of years, and I met him before COVID days, when we actually had face-to-face meetings in the NSAI headquarters in north of Dublin with Charlie and Catherine and a couple of others who were in on this call. And that forum, the TC45 meeting, is those people who help the National Standards Authority and who represent Ireland in developing the international standards for innovation management. So ISO 56001 was the main and the first, 56002 was the main and the first of those standards that Joe contributed to directly. And there's now a suite of those standards that Joe, Charlie, Catherine, Harlan, who's also on this call, are contributing to. Harlan represents the states on a couple of those standards, particularly 56008 innovation measurement, which is a really interesting up and coming one. And Joe is also particularly active on the IP standard, which may get a name check. I don't think Joe will want to take us through chapter and verse, but just bear in mind.
No, don't have time for that, Owen.
Yeah. Just
even if I could.
Yeah, that such a thing does exist, and for the people who really need to check this out, that ISO is a really good reference. Mr. Doyle, over to you. Have at it.
Thank you very much, Owen and Charlie, and to the wider community for the invitation. It's a brave move opening your 2022 with a talk on IP. It's not always the most engaging subject, but I'm going to try and take a more informal approach to it than we might be familiar with. So let me just start my slides here. I hope you can see my slide there.
Yep,
I hope
good to go,
can hear
Joe.
me okay.
Yep, thank you.
Good. So I'll just move this down off the screen. Right. So as the guy said, I'm the IP manager in Enterprise Ireland. I should say I'm not a patent attorney. I'm not a lawyer. I approach intellectual property from a business development perspective. So in my world, everybody needs an IP strategy. And more so these days, as the driver of value creation is innovation, and the output of innovation is often intellectual property. So what I want to talk to you today is about IP strategy. We have a habit of talking about the success stories, which is great, but there are fewer of those than there are of the failures. And also, I think failures and mistakes are a better way to, there's more to learn from them. So like the guy on the net here, we very often set out with good intentions and possibly get it wrong along the way. So what I want to do today is talk about a few pitfalls that I see in my job fairly frequently, and I'm going to use some fairly well-known examples to demonstrate those pitfalls. So I'm going to cover from my world the kind of 6 deadly sins of IP strategy. There are many more, but there's a limited amount that we can cover. And I hope this will be a conversation. I'm not going to get into anything in too much detail. And in the slides, which I think you will get afterward, I have some links that for anyone that's interested in digging a bit deeper, there'll be some useful information there, I hope. So before we start, are these really your most valuable assets? So I get this reaction quite a lot. Yeah, right. But so just to set that context, this is from a LinkedIn post that I saw last week, but it's based on data from the European Patent Office from 2019, which shows that really intellectual property is the basis of a lot of the value of companies today. Companies are with IP, with a bundle of IP, are about 100% more likely to have higher revenues than those that don't. SMEs that have any IP right, any registered IP right, are about 70% higher revenues than those that don't. The IP is a great way to communicate the value of a company, and those that have IP can communicate that value much more strongly. But unfortunately, the vast majority of SMEs don't actually own IP. Now, SMEs are not a generic category, but there's more than 10% of SMEs innovating, yet less than 10% own IP, and only a fraction of that own patents. So that's the starting point, and that's why this is of relevance to Enterprise Ireland. I should maybe mention what Enterprise Ireland do now, as Owen mentioned that at the beginning. We are the National Enterprise Development Agency, and our role is to develop Irish enterprises with export and innovation potential to help them to grow and to scale in global markets. My role in that is to help companies to understand and implement an IP strategy that drives their business plan. So that's the background. So the 6 deadly sins of IP. I'm going to talk about the different forms of IP and an example of each, where companies have got it wrong, and the lessons that even smaller companies, any company can take from these examples. So, and as it's lunchtime, I thought this would be a good one to start with. So Big Mac, you would imagine an entirely invincible brand. However, every company has a brand. It may be a company name, product name, or so on. And that can be protected by a trademark. So that's fine. You can protect a trademark, and you should protect your brand with the trademark. But there's more to it than that. If you don't use it, you will lose it. So in this case, McDonald's lost their European trademark right to the Big Mac brand because they were challenged by the Irish fast food chain Supermacs. So the Supermacs proved that McDonald's weren't actually using the brand as they should under the terms of trademark registration, and so that they lost that right in Europe. So the lesson here for companies, for SMEs, is that one, yes, you must protect your brand as a trademark. If you don't, you don't have that right to stop others from copying your brand, or you're less likely to have that right. But secondly, when you do have that right, you have to manage it, and you have to be able to show that you have proof that you're using it. So in my world, that's a very common mistake that companies and SMEs make. Registered designs. Here's another example of a very common form of intellectual property. In this case, the infamous Crocs, loved and hated in equal measure. They had a European-wide registered right for their design. And what the registered design covers is the look and the feel of a product, a unique aesthetic, which definitely applies in the case of Croc. Now, they also had imitators all over the place. One of those imitators did their research, and they found that Crocs had launched their product 10 years, some 10 years earlier than when they registered for their design right, had sold 10,000 pairs of them. And so their competitor was able to have their design right invalidated in Europe so that they were more free to imitate and copy the product. So again, the company tripped themselves up by disclosing their product and not protecting it within the time frame that they were allowed. And again, this is something that's very common, where companies get carried up in the enthusiasm of getting out into the market and making that first sale and being first to market and so on. There are risks with that, and those risks tend to put their head up some way further down the line. So don't disclose too early. Don't know if anyone is familiar with this photograph. It's called the Selfie Monkey. The chap here is a photographer, and he set up his cameras in the jungle in Indonesia. He was taking photographs of these monkeys. He headed off into the bushes for whatever reason for a while. And while he was gone, this monkey came up to his camera setup, looked into the shutter and pressed the button and took this photograph. So that's an original expression, and so there's copyright attaching to that photograph. The photographer assumed that he had the copyright. However, when he sold the picture through various outlets, Wikipedia picked it up, and they said, well, hang on a minute. The monkey took the photograph, so the monkey owns the copyright. So we're free to distribute this. It's quite a long story. There's a link there to some information on it. But essentially, it evolved so that an animal rights group representing the monkey sued him for copyright infringement, or for taking the monkey's copyright. To cut a long story short, the photographer won out in the end, but it took several years. So the lesson here for companies, and everyone has copyright. So if you're getting somebody to create something for you, you need to get them to assign that copyright to the company, or it's not automatic that you own the copyright to what you've asked them to create. I don't know if anyone's watched this series on Netflix. If you haven't, I'd recommend it. These guys here were entrepreneurs in Germany back in the 90s, and they developed a technology that was essentially the precursor to Google Earth. To get long story short again, in their enthusiasm of engaging with big companies like Google, they essentially allowed or made it easier for Google to take their idea without giving them their relevant cut of the returns. So their technology was the basis for Google Earth. I won't give a spoiler if you haven't seen the series, but it's a great example of how not to engage with a large company. Large companies are very exercised, very experienced, and have lots of people helping them to implement their IP strategies. So companies, it feels like the might makes right principle applies. Actually, it doesn't. If you engage with a large company strategically and make sure that you have your IP well nailed down in advance and have a strategy in place, it is possible to engage, but there are serious risks if you don't. There's so much that could be said about patents that I could keep you here all day, and I won't do that, I promise. But there's a link here to a recent presentation I saw on LinkedIn on YouTube that I think is a really good presentation. It's about an hour long on patents that I would recommend taking a look at if you get a chance. So then licensing, it's another area of intellectual property where there are many pitfalls. And what I want to point out here is that there is no such thing as free. There's a lot of talk about free license, open agreements, and so on and so forth, open source. There is no such thing as free. Nothing is for free. You always have to give something away. And this example here is Tesla in 2014. They made a pledge that they were going to make all of their patents open source, which sounds utterly wholesome and wonderful, and what could possibly go wrong? I mean, look at that innocent face. However, the agreement that you would have to sign up to with Tesla commits the other party to pledge more than Tesla are pledging in their open source agreement. So there is always a price to pay, and companies really should enter into licensing. They should enter into licensing. Licensing is a great idea, but you should enter into licensing with your eyes wide open, that nothing is for free. That includes open source licensing of software. And make sure that you're getting good advice and that you review all of those agreements. The sixth deadly sin relates to technology transfer. This poor dude here is your typical technology transfer officer or the entrepreneur that's engaging in a technology transfer project some way down the line. It's very hard to work your way back if the preparation isn't done up front. So the key lesson here from my experience of talking to companies engaged in this sort of activity is do not mix up the inputs and the outputs. Up front, know what your background IP is. So a lot of companies go into collaborations without knowing really what their background IP. And what I mean by background IP is the IP that you own going into whatever the third party engagement is, whether it's a collaboration or technology transfer. So companies really should know what their IP is. And if it's know-how, then that's really not IP. That's something that's rattling around in somebody's head, and it's very hard to manage that. So if it's possible at all to codify your IP and protect it before going into an engagement, it really helps with untangling everything that possibly comes out at the other end of that engagement. So those are the 6 deadly sins that I wanted to cover. There is so much more that is possible to cover in this. I hope these are might be enough to start a conversation. There are a couple of other things that I just want to note while I have the floor that are of relevance this year. So one is the Unitary patent reform, which I'm sure most people here maybe, or I don't know, might or might not have heard about it. It's essentially a reform of the European patent system. In Ireland here, we have to have a constitutional referendum to bring into force a new patent court. This is a reform that's designed to make EU patent protection more affordable and accessible for SMEs. It's not on the radar at the moment. And this report by IBEC highlights that, and that we need to act to make sure that we are a full and active part of this reform. Again, there's a lot to be said about that, and I won't say any more, but I want to bring it to your attention so that hopefully, as this does come up in conversations, that the innovation community might get behind it. And finally, I just want to mention, selfishly, our own supports for companies to develop their IP strategy. So hopefully to try to avoid some of the pitfalls that commonly are encountered by companies, but also to give companies the power to retain some of the value that's being created through their innovation activities. So there are a lot of details there on the slide. I won't go through them, but I would greatly welcome any contact from anyone that would want to talk about any of these in some more detail. So that's my IP spiel. I hope my clock wasn't running there, so I don't know if I went over the target of 10 minutes or not. But anyway,
you did brilliant, Joe. So brilliant slides, really simple imagery, really simplified idea set. A few basic points, the 6 deadly sins. I know Charlie is putting up a comment there, is the equivalent to situation in Northern Ireland and the relationship or the comparison with Invest Northern Ireland, which is really useful to bear in mind given our audience today. So folks, at any stage, put up your hands or put your questions up on chat. We can deal with it in any way that suits. And I know that Brian Dernan has at least one, Charlie has one, and I, of course, have a couple myself. We might start with Brian. You got in there first, Mr. Dernan.
It's not often then. Listen, thanks, Joe. Great. Really, really enjoyed that. One of the questions I was going to ask you about is tacit knowledge, right? How that fits in with the whole issue on this, know-how, know what have you, and what you come to the table with. That tacit knowledge is always a little bit hard to quantify and perhaps even agree on. What's just your experience in dealing with that? Tacit knowledge being what's in people's heads.
Yeah. It's super slippery, Brian, to be perfectly honest, and there's no perfect solution. I guess what companies, so I deal with companies mostly. Okay, so I'm going to approach it from, say, that perspective. So what companies tend to do is that they're obviously kind of working on a short term, kind of keeping the money coming in, making sales, all that sort of thing. So you want to get things done. So you deploy your people to resolve problems, and so you're deploying know-how. And then you go into a collaboration with somebody, and it's the same habit. You deploy the know-how, the tacit knowledge. The problem with that is that a company doesn't actually own that. You don't own your employees. The only way to, you could stick them in a jar of formaldehyde or something like that. But really and truly, tacit knowledge is owned by the person that owns it. Know-how is owned by the person that owns it. And know-how goes to work for competitors. Know-how falls down the stairs, and know-how goes to the pub and chats to their friends. What companies, that's always going to be the way. And there's always going to be an amount of tacit knowledge. And it's an important part of the intellectual capital of a company, absolutely. But I guess from an IP point of view, what you're talking about is the company being able to convert as much of what they have in terms of intellectual capital into company-owned intellectual property, something that can be something that when everybody goes home at the end of the day, it resides in the company. So the starting point with converting knowledge or know-how or tacit knowledge into intellectual property is to convert it into a trade secret. So already it should be something that only the company knows about, but now it's the employees of the company that know it. So you get them to codify that information. That's done through processes like engineers' notebooks, through invention disclosure forms, through internal training, manuals, videos, whatever it happens to be. And so you're converting that know-how into usable information by other people in the organization. And then the organization keeps it secret so that only the people that need to know what it is can have access to it. So now you have both know-how and you have trade secrets, a codified asset that the company owns. And then within that, there are possibly inventions, designs, and so on that can be protected through formal IP protection, patents, designs, whatever it happens to be. So that's IP management. That's the in-house management of the knowledge that the company has and doing it properly. And then there are all the contracts that wrap around that as well, employment contracts and subcontract agreements and all of those sort of things. So that's a very long answer to that question.
No, Joe, thank you. You nailed that one for me. Thank you. I like the secrets. I like that one. That's a good road.
Trade secrets are really important. They're ubiquitous. Everyone has them as long as they keep them secret. If you don't keep them secret, you don't have it. Everybody has it.
Great, thank you.
Thanks for that question, Brian. While Joe was answering that, there was a comment from Martina. It's along the same lines. Hi, Joe, you mentioned know-how, not to have it just rattling around in your head. Could you elaborate, please? You may have covered that already, Joe, but Martina, if you want Joe to add some more comment. Oh, yeah, there you go. Thanks, Martina. I think you just answered that. Okay, before we then go on to Charlie's question. So if we compare that to the comment you made about Tesla. So Tesla's being disingenuous, but if you're being kind to Tesla, they are saying they don't always want to put things in a patent. They want to treat things other ways, for example, trade secrets, so that they don't have to put stuff in patent documentation that's open for others to understand better than Tesla might wish. Am I carrying things too farther, or is that being fair to Tesla?
So they do both, yeah. So they do. So yeah, absolutely. Tesla will have a burgeoning vault of trade secrets. There's no doubt about that, and that's not included in the Tesla pledge, right? So what the Tesla pledge does is they said we have a portfolio of patents. So that picture, that screen grab that I gave you there, and he's saying, I don't really like patents. Tesla love patents. They have quite a few patents. So what they're saying is we're going to make our patents open source to you. You can license our patents. We're not going to charge them for you. But in return for that, you've got to agree that you're not going to assert any of your patents or any other intellectual property that you own, including trade secrets, against Tesla or against anybody else. So all of your IP is rendered essentially useless to you, but useful to us. So I don't know if that's disingenuous. I think it's probably very clever, but it's I wouldn't sign up to it. I'd say that.
Brilliant, really good clarifications. Thank you for that, Joe. Charlie, I think we're over to you.
Yeah, well, as ever, I've got 2 or 3 questions, but I'll limit it. First one is as a follow-up to the trade secrets. Can a trade secret be as simple as a documented process that you use to deliver a particular service? Can it be that simple, or is there more to it than that?
Absolutely. It's what's of value to the company. There are kind of there are 3 characteristics of a trade secret. One is that it should be new, so it's not common knowledge, right? So that's kind of clear. It has to be of value to the company. So the company canteen menu might be secret, right? People might not want to post it on LinkedIn or Twitter or whatever, but it's not really of value. If it does get onto Twitter, the company is not going to lose value. So whatever that the information is, it has to be of value to the company. In other words, if the company loses it, the company loses value. And then thirdly, the company has to make best efforts to keep it a secret. So in other words, if they find themselves standing in front of a judge someday, they'd be able to show the judge the processes that they've implemented to maintain it as a secret. If you can't do that, then the judge will say, well, okay, it's of value and it's new, but you didn't try to keep it a secret, so.
Okay, and is it as simple as categorizing that document or that process as confidential or commercially confidential or something like that? That is just
no,
putting a marker
on it?
It's not
as simple as that. There are a number of steps to make best efforts. If you think about the number of ways that something could escape out of a company, if everybody in the company knows about it, knows the secret ingredient or the secret process or whatever, then it's not a secret. Only the people within the company. So those sort of processes. When you're bringing employees into a company, they should have an interview to say, are you bringing other people's trade secrets in here? We don't want to know what they are, but we want to know that you have them and that you're not going to use them here because we'll be in trouble. Equally, when employees are leaving, there should be an exit interview. And then you have all of the contracts and all of those sort of things should stipulate what people should do.
Okay, thank you for that. My proper question was actually going back to one of the earliest things you said about I didn't note the percentage, but the revenue that SMEs gain, or the increase in revenue from SMEs that have IP, is that license sales, or is it triggering other revenue?
No, I think that report. So, like I said, that's a report that was done by the European Patent Office. What they did really was essentially comparing companies that have formal IP, registered IP in this case, to companies that don't have it. And they picked a few kind of indicators like revenue per employee, average number of employees, number of things like that. So it was revenue across the business and just comparing those businesses, the ones that have the IP and the ones that don't. So they didn't attribute it back to a particular patent or a particular trademark or anything like that. It's not that granular.
So it's almost a sort of a mindset thing. The same way as people say that innovative companies are more successful. I mean, it's kind of It's not necessarily the innovation itself, but it's because of the mindset and the way that they approach things.
It's that, but also when it comes to intellectual property, if a company so a lot of companies go, we got to get out to the market. We want to be first to market. We want to start generating sales quickly. And you go out there and you do essentially what Crocs did. Okay, you go out and you make a load of sales, and when you're making those sales, you're putting your product out in the market, so you're disclosing the innovation that's embodied in the product. If it's not protected, then competitors in the market can take a look at it and say, okay, I like the look of that product, I like that feature, I can check the database to see if it's protected. Okay, it's not protected, so I'm free to copy it. So essentially the company is in the rush to win market share, they're giving their idea away for free to somebody to copy it or whatever. And it's impossible to measure that loss because the company never had the gain that the copycat gets. So if a company does take the steps to protect the intellectual property, then you have something to measure. So you say, okay, you infringed my patent. Nobody wants to get in that situation where you're asking somebody to hand over the profits that they made from infringing your patent. But if you don't have the option to do that, you simply don't have the option.
Yeah. Okay, thanks, Joe. Thanks very much.
Joe, while you guys were talking, we had a comment from Declan just emphasizing the value of negative results. So can you comment on that in the context of trade secrets?
Okay, so assuming that I understand what you're referring to there, Declan, so in innovation, we get more things wrong than we get right. And developing any new product, you go through an exercise of disproving all of the ideas that you thought might work. If you keep those things secret, say you do 100 experiments, 99 of them were failures and one was right. If you keep all 100 secret, or rather if you disclose the 99, then you're teaching your competitors how the solutions to not bother trying. You don't really have to try those 99 experiments to get to our one solution that worked. I think that's the gist of the question. So you don't want to go and file a patent and say we tried A and it didn't work, we tried B and it didn't work, and we tried C and it didn't work. So you keep that information secret so that other people will fall into the same manholes that you fell into to get to your solution. You don't want to teach the world how to solve the problems that you solved.
You don't want to show people why you did what you did.
Yeah, the why. There's a development route always that's got, you think, oh God, if I put A and B together, I'm going to get C, but you discover you've got Q, and there's an awful lot of learning in that. So that learning is something that somebody else that wants to copy your product would have to go through. I think there's a lot of talk at the moment around the vaccines and whether companies should waive their patent rights. So, which is a total phony war, because if you get your patent on how to manufacture a vaccine, a key active ingredient, whatever, it tells you nothing about all of the other stuff that you need to do to get to the point of being able to do that. All of the other mistakes that company made along the way. The patent really is not going to help you. So a huge amount of that information is that trade secret information that those companies have developed through going through the process of development.
Brilliant. Okay, Joe, that's a really great question from Charlie. And I know we could go on that subject actually for the rest of the hour. But there are a couple of things on chat. Now, Catherine, I don't know if your microphone is working, but what Catherine has written is, thanks, Joe. What is your view on barriers and blockers to open or collaborative innovation? Research saying that fear of losing IP is a barrier, but if SMEs don't have it protected, okay, is it all down to trust?
Fears, barriers and blockers to open innovation. So fear of losing IP is a barrier. So yeah, I don't know. There are two ways you can approach that, right? So if you own the IP and you go into an open innovation, you can go into open innovation with patents. Many open innovation engagements are based on patents and formal IP protection. So kind of like the guy going into the tangle of wires, right? If you know what you're going in with, and you're going to own that when you come out, and we're going to share openly what we create together, that's an open innovation. if the fear is that we're going to go into this research and we're afraid that we're going to lose some other IP that we haven't yet protected, then that's a rational fear. And so the question is, should you go into that engagement with your ideas in your head? Nobody owns an idea. An idea is a chemical process in your brain, right? Everybody can have the same idea. Unless you've protected that idea in some form of IP or as a trade secret, or that you've codified it in some way that you can say, I'm sharing this with you, and it's going to be mine after I share it with you. It's very hard to be sure that you're not going to lose that if you call that IP. I don't know, Catherine, am I addressing the question?
A lot of, particularly in Ireland, we're really bad at collaborative innovation, and some of the research is showing is that there's this fear of, they're going to take my idea, a bit like probably doing deals with Tesla. That you're going to come out with less than you went in with.
So I think that's kind of the point that I was trying to make around the inputs and the outputs. I think a lot of companies go into these collaborations without fully understanding what they're inputting. They know their skills, they know they've great people, they know they've great ideas and so on. But all of that stuff gets thrown into the washing machine together, and it's very hard to separate it out afterward. There's no ideal way. It's always going to be somewhat difficult. But in my experience, I think that's a pitfall that a lot of people do. And so they're going in and they're saying, okay, all the IP that's going to come out of this project is going to be owned by the university or the other partner, or whoever it happens to be. But that's not the case. If you go in and say, this is my IP that I'm going in with, that's going to be my IP throughout the project and my IP at the end of the project. And so now all we're talking about is the IP that's generated by the combination of our existing background IP and the work that we do. So you don't, if you throw it all in together, then you can lose it.
Okay, thank you.
Thanks for the question, Catherine. Now there's a comment in here from Martina, which is really looking at the costs. Now you can look at the cost of doing IP, the cost of not doing IP, the analogy of training, that the only thing more expensive than training is not training. So we can have that perspective on costs for IP. But if we just take the narrow version, what are the actual costs? Where are the resources needed to do IP well?
Jeepers, how long do I have to answer that question?
Yeah, we only do.
There's no doubt about it. It is not difficult to spend money in this area. Okay, but so this is Doyle's law, right? I think there's an 80-20 problem. 80% or thereabouts of the work that has to be done in a company or whoever around managing IP is stuff that has to be done in-house, and it's with a bit of knowledge, it's eminently doable by most companies. Takes some time for sure. 20% of the work is done by rather expensive experts, okay, patent attorneys, lawyers, and so on. Really, really important. You can't get the 100% without that 20%. It's very important to have them. What we do, unfortunately, also, and 80% of the cost is in that 20%. Probably more than 80%, but anyway, say 80% of the cost is in that 20%, and 20% of the cost is in the internal part. So now, if you don't do the internal 80% and you save yourself that 20% of the cost, now 100% of the cost is in that 20%, and that 20% of your activity is reactive. So you're saying, oh no, we've got a fire, we need to bring somebody in to put out the fire. So you bring in a lawyer or a patent attorney, and that's super expensive. That's really how not to do it. That's really expensive, to bring in experts to fix situations that the company should have been doing. So in terms of how to minimize the cost, a company really should be aware that there's a lot that they can do themselves and start to manage their stuff internally, secrecy, documentation, training, all of those sort of things, agreements, doing all of that as right as is possible, and then proactively bring in the expertise to plug the big gaps, right? And so you're minimizing the cost
Sorry, Joe, important question. Have you copyrighted this Doyle's Law now?
No, it's that the Doyle's Law term is all of 5 minutes old, I think. But it's not based on. It's based on talking to a lot of companies and seeing a lot of companies make the same sort of mistakes. It's understandable. IP is a long-term play. If you file a patent today, right, you're not getting any return on that patent for quite a while, and it's going to cost you a lot of money. One of the cost question always comes up. You know, if you want to file a patent for one invention, you want to have a budget of about 20 grand for 2 years to 30 months, and after that it starts to get expensive. So yeah, you need a budget for it. You need to anticipate that it's going to cost you money. But if you want to minimize the cost, you want to minimize the number of problems that are going to arise in the future. And no problem will arise if you're not making any money. So when you're a startup or when you're a small company, honestly, nobody's going to give a damn. Nobody's going to pay you any attention. And you're going to look around to all your colleagues and say, you having problems? You having problems? Do you have IP? Do you have IP? IP is not important. Then you get to a point where you're being successful and you start to eat your competitor's lunch, and the competitor happens to be a billion-dollar, multi-billion-dollar company, they will come down on you. You can be guaranteed only when you're successful, though. So that's some point in the future. So you have to take medicine today for that eventuality in the future.
Brilliant. That was for Martina's comment. So I think you've addressed that comment, but Martina will tell us if you haven't. I know from history. Thanks, Martina. I've got a question then, Joe, which reflects the fact that we've had 16, 17 people in today's chat, and now we have definitely 2 and maybe more who are working in the public sector in Ireland. So I wonder if you're able to comment or advise on, you know, what does IP mean for the public sector, which is very broad, or a couple of examples of where IP is important in public sector organizations.
In public sector innovation specifically, or the public sector mandate for economic development?
I think we're talking about innovation given the present audience, but the second one is relevant too.
What does it mean for public sector innovation? So there's lots of different shapes and sizes of public sector innovation. I think, you know, it'd be unlikely that Enterprise Ireland would be going out patenting ideas that we happen to come up with at work. There's no benefit to the taxpayer in that. But, you know, every agency, say like Enterprise Ireland, comes out with programs that we call XYZ, you know, IP Start, right? Whatever it is. Do you want necessarily an agency in some other part of the world to come out with the same, to copy that directly? Maybe you do, but it would be best to do it in a way that the creators, i.e. the taxpayer represented by the agency in Ireland, get some recognition for that, and that bolsters the overall impression of the public service as an innovator. So there can be good reasons to say protect the brand of things like that, or to yeah, patents, I don't know, it's hard to know. In the health sector, there's lots of work going on, lots of innovation where, yeah, the public sector are filing and should be filing patents. So there are different scenarios. I think every country needs an IP strategy, okay? And yeah, that's really what goes into it, I don't know. But there's a relevance in the public sector that's different to, it's not profit motivated maybe, but there's certainly value being created, and if you can retain that value for whatever purpose, then use the IP system.
Brilliant. And I know that's a conversation that we've been invited by others to start with some public sector colleagues, so we'll come back to that. But I know there's a question from Aileen now, and maybe Charlie after that.
Hi, Aileen.
Thanks guys. How are you, Joe? Thanks for that, it was brilliant. An awful lot of what you were saying kind of meant an awful lot to me from, you know, being in the food sector. I know I've moved on now to the tourism sector, but I've been in the public sector, mainly in the fish sector with BIM for the last 10 years, developing new products in an innovation centre in Clonakilty.
Yeah.
And we had come up, you know, about this whole area of IP quite a lot, because some businesses might come in to us to develop a product, and like you just said, nobody gives a damn if it's just something small and they're only small, but then you have a big company develops out of an amazing idea, and we really had to be equipped to advise them, you know, of either the new technology or the new recipe or the new process. And my question is, like, so we were a public agency, you know, with all the secrets, right? Because we were developing it, while let's say the fish company were the ones probably that were going to be the ones to you know, scale the whole thing up.
Yeah.
And one in particular became extremely successful, exporting, you know, all over the place. And I'm just wondering, you know, while we were able to advise them to a certain extent, we might have had a university stuck in it at some point with, you know, they might have used an innovation voucher, let's say with, take for example, UCC or St. Angela's College or someone like that. So my question is, at what point, like, are they patenting, you know, the process, or is it the brand, or is it the product when they eventually became so successful? Because it happened very quick, you know, it happened very fast. So just wondering what you think, because I'm looking at the Big Macs thing there.
Mm-hmm.
And I was just wondering around Big Mac is a kind of a different thing. It was all about the brand, but a lot of what we would have been developing was mainly around either a new piece of technology or that secret recipe, which really was never, you know, going to be a secret for too long.
Yeah, so it's never just one thing. You know, when you create something new, there might be a technical invention in it. Okay, and that technical invention is like a technical solution to a technical problem. So then you're talking about a patent if you want to be published in a patent, or you keep it as a trade secret if you don't want it to be published in a patent. If it's something around the brand, you know, you come up with a clever name for whatever the thing is, you can protect that as a trademark. If it's the look and feel of the thing, the aesthetic, that's a registered design. So those are kind of the formal IP protections.
Okay.
So whatever it is that you're creating, it will have different features, and there'll be different aspects to it that you would say, okay, that's distinctive about our thing. We want to own that feature via a patent or a design or whatever it happens to be. So you can't really say, you know, I'm going to go into a project with this, you know, say fish farming company, and at the end of it, I'm going to have 5 patents. You know, what you have to do is you go into the thing and you have a way to manage your innovation, that you're capturing the data as it's created, and you're saying, and you audit it every so often and say, okay, that there is an invention. We could potentially patent that, or, you know, there you have these different aspects to it. So it's a broad IP management activity that you have to undertake, rather than if I'm answering the question.
Yeah,
that is the question. I'm not so sure.
So it could be all. It could be the full package.
Absolutely, it should be. That's why we recently reframed our support in this area to call it IP strategy rather than IP protection. Because IP protection, you say that, and you say IP, people automatically think patents. Patents are great, I'm all for patents, but they're a specific purpose tool, and they definitely don't apply in 100% of situations. So you have lots of different forms of IP. And I guess one thing that applies across the board, but definitely applies in the public sector, is data. So, our databases, if you like. So data is generated by all this stuff. Everyone's generating data, right? And there's a lot of talk about owning data and sharing data and giving me my data. That's my data. That's your data, and so on. In reality, data in an unstructured format is just noise. Okay. What we do in a lot of projects is we collect data in a structured way, and we store it in a database. So you can't own the data. I can't own the word Joe, right? But if I apply to Joe, to Doyle, and my age, my height, my location, and so on, I'm creating a database, right? So that database applies specifically to me. So I have certain ownership over that. Same applies to a research project. You collect data via a number of different sources. Via a structured approach, you create a database. And what you have there is a database right. So it's a kind of a legal right. not very well done everywhere consistently around the world, but it exists. And then you have your collection methods, maybe a software code, right? And that's protected by copyright. So you have these overlapping rights that cover in every company in the world, really, but also in every public sector agency. The data generated, the databases generated by that agency. And if you take the health service executive here in Ireland, for example, can you imagine the amount of data that they accumulate on a daily basis? They might not want to go and license it out to willy-nilly, but there are times where they might. And if it's not structured as an asset, it's very hard to do that. So there are lots of things to
thanks.
That question
Thanks,
and
Joe.
timing, I would say we probably could go on for an hour on that one, but I would just please that if we give Declan the chance for the last question, and then Charlie will try and close it out for us within the next couple of minutes. Declan, are you still with us? Can you hear us? Yes, welcome.
Yes, hi, thank you. Thank you for the presentation. And Joe, I have kind of maybe a tricky question, because I agree with you entirely that IP is expensive. Are you aware of a successful IP company that would use the cheapest IP rights, meaning copyright, trade secrets, and just publication, just disclosure of all innovation, and then just relying on brute force of marketing to sell your product? Are you aware of such a strategy that has worked or has failed?
And essentially to avoid having to file patents and
yes,
and so
exactly.
On. Yeah. Actually, I was on one of these webinars recently with a company in the UK. I can't remember. I think First Light is the name of the company. So I'm not disclosing anything. They were talking about this on a webinar. And what they do is they're in the whole fusion energy area, right? So huge amount of technology development going on, a huge amount of potential IP and so on. And they could file a patent every half hour. It's so deep tech. So what their strategy, he was saying, is that they patent some things, but they're really, really selective on what they patent. They're also essentially a startup, so they've a very limited budget, and it's very expensive technology. So they have to be really selective about how they use their money. So they keep a lot of stuff trade secret. So they have a very robust trade secrets policy, and everybody in the company is kind of well educated on how to manage trade secrets. And they then publish a huge amount of stuff. So the reason for publishing as part of an IP strategy is saying, okay, look, this is something new, but we're probably, I don't know if it makes sense to patent it, but we don't want anybody else to patent it. So we're going to put it out into the public domain. And now if somebody goes and files a patent in that field, we can say, well, hang on a minute, we published that. That's in the public domain, so it's not patentable. So yeah, that's why you need a broadly based IP strategy. You have to be looking at all of those different angles, and it is around cost savings as well. Lots of companies use trade secrets. Trade secrets, you don't have to register them anywhere. You know, WD-40, Coca-Cola, Google.
Right. On that note, Joe, I think we have stolen your brain. And I think you've done very, very well out of that, Joe. Thank you ever so much. Mr. Tuxworth, I think it's your turn to bring it out of the building.
Yeah, just echo your thanks, Owen. Thanks so much for that, Joe. I know you said before we started you had some concerns it might be a dry subject to start the year, but it was extremely interesting and enlightening. And like the tax discussion we had last year, it's opened a few eyes, I think, as to stuff we should be really having a better look at. So the recordings and the slides for this will be made available via LinkedIn over the next day or two. Next week we have a coffee stop, so a very informal, small gathering with no agenda where you end up talking about anything. And then the following week, we're hoping to run through the Innovate Ireland strategy and plans for 2022, and maybe seek some of your input and ideas on how, as a community, we can best deliver on those plans. So just to close, just to say thanks again, Joe. Thank you for everyone around the world joining us today. Have a great weekend, everyone, and hopefully catch up with you all soon. So thank you very much indeed. Thanks.
Thank you very much, guys.
Brilliant.
Thanks for the opportunity.
Thanks, everyone. Thanks, Joe.
Appreciate it.